It was the kind of moment that stops a courtroom cold, the kind of moment that makes seasoned attorneys grip their legal pads a little tighter, that makes court reporters pause mid-sentence, and that makes observers in the gallery exchange wide-eyed glances with one another. A federal judge, appointed by a Republican president, a jurist whose entire career trajectory was shaped by conservative legal philosophy, sat elevated behind the bench and unleashed something that nobody in that courtroom had quite expected. Not a gentle rebuke, not a carefully worded procedural warning. What erupted from that bench was something far more visceral, far more significant, and far more consequential for the future of American democratic governance. A sitting Republican-appointed federal judge had reached his breaking point, and he was making sure everyone knew it. What happened inside that federal courthouse sent shockwaves rippling far beyond the walls of the courtroom itself. It traveled through legal circles, through political corridors, through newsrooms, and through living rooms across the country. Because when a judge who shares the same political pedigree as the president being challenged decides that the conduct before him is simply too far beyond the pale to tolerate in silence, it means something profound. It means the resistance to executive overreach is no longer just a partisan affair. It means that some of the very people who helped construct the architecture of this administration's judicial ambitions are now standing in open opposition to the manner in which that power is being exercised. To fully appreciate the magnitude of what unfolded in that courtroom, one must understand the broader legal and political landscape into which this moment arrived. The Trump administration, now deep into its second term, has pursued an aggressive posture toward the federal judiciary that is without modern precedent. From the very opening weeks of this administration's return to power, the executive branch has treated court orders, injunctions, and judicial directives not as binding mandates of law, but as inconvenient obstacles to be navigated around, delayed, minimized, or outright defied. The pattern has been consistent, deliberate, and deeply alarming to those who study constitutional governance. Federal judges across the ideological spectrum have found themselves issuing orders that the administration has either ignored, selectively complied with, or challenged through procedural maneuvers clearly designed to exhaust the judicial system's patience rather than genuinely engage with the rule of law. Immigration enforcement orders have been executed in direct contradiction to court mandates. The removal of federal employees, the disbanding of agencies, the cancellation of congressionally appropriated funding, all of these actions have proceeded at breakneck speed, frequently without regard for pending legal challenges or active court orders demanding restraint. The judiciary has been watching, and increasingly, judges across the country have been speaking up. But there is something categorically different about the moment in question. Something that cuts through the noise of the ongoing constitutional crisis and demands focused attention. This was not a Democratic-appointed judge expressing frustration with a Republican administration. This was not the predictable friction of opposing political philosophies clashing in a federal courthouse. This was a judge with Republican credentials, appointed through a conservative political process, who had operated for years within the legal tradition that the Trump movement claims to revere, and he was erupting, not performing, not posturing, erupting with the kind of authentic judicial fury that only emerges when someone who genuinely believed in a system watches that system being dismantled in front of their eyes. The case before the court was one of many in the current flood of litigation challenging the administration's sweeping executive actions. Across dozens of federal courthouses, plaintiffs ranging from terminated federal employees to immigrant families to nonprofit organizations to state governments have been racing to the bench seeking protection from an executive branch that has demonstrated time and again that it views legal constraints as suggestions rather than commands. The sheer volume of litigation has been staggering. Legal scholars have described the current moment as unlike anything in living memory, a constitutional stress test being conducted in real time, with consequences that will shape American governance for generations. The specific matter before this court involved conduct by administration officials that the judge found not merely legally questionable, but personally offensive to his understanding of what the law requires and what the oath of judicial office demands he protect. Government attorneys had appeared before him making representations that subsequent evidence suggested were, at minimum, misleading. Documents had emerged. Timelines had contradicted sworn statements. The gap between what administration lawyers had told the court and what the record actually showed was not a matter of interpretation. It was a matter of plain fact. And this judge, a man with a long record of judicial restraint and measured legal reasoning, was not prepared to let it pass without a full and direct accounting. What made the confrontation all the more striking was the visible discomfort of the government attorneys in the room. These were experienced lawyers, individuals who had navigated contentious litigation before, who had faced tough questioning on the bench, who understood that judicial scrutiny was part of the job. But what they encountered in this courtroom was different in kind from routine judicial skepticism. The judge's voice carried something beyond legal rigor. It carried the weight of a man who had spent decades upholding a system of law that he now believed was being actively subverted by the very executive branch those attorneys were there to represent. He did not mince his words. He questioned directly and with unmistakable clarity whether the government's representations to the court could be trusted at all. He referenced specific instances in which he felt the court had been misled. He spoke about the foundational principle that the executive branch is not above the law, that no president, regardless of political affiliation, regardless of claimed emergency powers, regardless of electoral mandate, possesses the authority to simply disregard judicial orders. And he stated, with the kind of precision that only comes from genuine conviction, that what he had witnessed in the proceedings before him represented a serious threat to the constitutional order that he had sworn an oath to protect. The reaction from administration officials was swift and predictable. Spokespeople and political allies rushed to characterize the judge's remarks as partisan, as activism from the bench, as an example of the judicial overreach that the administration has long claimed is plaguing the federal court system. The framing was familiar, an attempt to transform a legal confrontation into a culture war skirmish, to paint the judge's outrage not as a principled defense of the rule of law, but as evidence of a deep state judiciary aligned against the people's chosen leader. It was a narrative that had worked before, at least within certain media ecosystems and political communities. But it was considerably harder to sell this time, because this judge was not a Democratic appointee, because this judge did not have a history of progressive rulings, because this judge was, by every conventional metric, exactly the kind of jurist that the Republican legal establishment celebrates. And he was furious. The broader constitutional context in which this confrontation occurred cannot be overstated. The Trump administration's relationship with the federal judiciary during its second term has been defined by escalating confrontation. Early in the year, the administration moved with extraordinary speed to implement sweeping executive orders, knowing that legal challenges would follow, but calculating that the pace of implementation would outrun the court's ability to respond effectively. Federal employees were terminated en masse before reinstatement orders could be fully enforced. Immigration operations were conducted in jurisdictions where judges had issued stays. Agencies were gutted and reorganized in ways that appeared designed to render court orders moot by the time those orders could be enforced. The administration's legal strategy has reflected a coherent, if deeply troubling philosophy: move fast, create facts on the ground, and challenge the practical ability of courts to reverse what has already been done. Legal scholars have identified this approach as a form of constitutional hardball, a deliberate stress testing of the limits of judicial authority, predicated on the calculation that courts ultimately lack the enforcement mechanisms to compel executive compliance if the executive is sufficiently committed to noncompliance. It is a dangerous game, and judges across the country have been watching it unfold with growing alarm. The Republican judge at the center of this confrontation had seen enough. His record on the bench reflected a man who took the separation of powers seriously, not merely as political theory, but as operational reality. He had, in previous rulings, demonstrated his willingness to rule against parties on both sides of the political divide when the law demanded it. He was not a man given to grandstanding. He was not a man who courted controversy for its own sake. He was, by every account of those who had appeared before him, a serious jurist who believed that the integrity of the judicial process was a sacred trust, and it was precisely because of who he was, because of his credentials, and his judicial temperament, and his political pedigree, that his explosion in open court carried such extraordinary weight. What he articulated, through controlled fury and precise legal language, was essentially a declaration that the administration's treatment of the federal judiciary had crossed a line from aggressive legal strategy into something that threatened the foundational architecture of American governance. He spoke about the role of courts in a constitutional democracy. He spoke about what it means for citizens to have faith that the law applies equally to all, including to those who wield executive power. He spoke about his own obligations under the Constitution and under his judicial oath, and he made clear that those obligations were not negotiable, that they could not be overridden by political calculations or executive preference or the sheer velocity of policy implementation. The specific legal issues at the heart of the case were complex, as federal litigation invariably is, but the judge's broader message transcended the particular facts before him. He was speaking to a pattern, not just an incident. He was placing into the public record a judicial assessment of the administration's conduct that went beyond the four corners of the case file and addressed the systemic challenge that executive defiance of court orders represents. This was, in a very real sense, a message from the judicial branch to the executive branch, delivered not through formal interbranch communication, but through the raw, unfiltered mechanism of a federal judge saying, in open court in front of government attorneys and members of the public, that what was happening was unacceptable. The legal community responded with a mixture of relief and anxiety. Relief because many attorneys and legal scholars had been waiting for a judicial voice of this particular profile to speak with this particular force. For months, critics of the administration's legal conduct had been warning about the erosion of judicial authority, but those warnings had come predominantly from predictably oppositional sources. A Republican-appointed judge speaking in these terms introduced a different dimension to the conversation, one that was harder for the administration's defenders to dismiss as partisan noise. The anxiety came from the recognition that the judge's fury, however justified, however legally grounded, however constitutionally significant, ultimately depended on the executive branch choosing to respect judicial authority. And that choice, increasingly, was not being made. This moment arrived against a backdrop of growing international concern about the stability of American democratic institutions. Allied governments, foreign policy analysts, and international legal scholars had been watching the escalating confrontation between the Trump administration and the federal judiciary with deep unease. The United States has long positioned itself as the global standard-bearer for the rule of law, a model of constitutional governance that other nations are encouraged to emulate. When that model appears to be under strain from within, when its own executive branch appears to be engaged in systematic disregard for judicial authority, the consequences extend far beyond American borders. European governments that had already been unsettled by the administration's foreign policy posture, its ambivalent relationship with NATO commitments, its transactional approach to international alliances, its apparent sympathy for authoritarian leaders abroad, were now confronted with evidence that the institutional dysfunction they had been observing was not limited to foreign policy. It reached into the domestic constitutional order. It reached into the relationship between the branches of government. It reached into the fundamental question of whether the United States remained a nation governed by law or was transitioning toward a nation governed by the preferences of a single executive and his inner circle. At home, the political ramifications of the judicial confrontation were immediate and significant. Democratic lawmakers seized on the judge's remarks as confirmation of what they had been arguing since the administration's return to power, that the executive branch's conduct represented an unprecedented assault on constitutional norms. They called for congressional hearings, for investigations, for formal accountability mechanisms. Their voices carried the passion of people who felt vindicated, but also the anxiety of people who recognized that vindication meant the situation was genuinely as serious as they had claimed. Republican members of Congress found themselves in the by now familiar position of having to choose between loyalty to the administration and fidelity to constitutional principles they had claimed to hold dear. Most chose silence. Some offered tepid defenses of the administration's actions. A handful, a small but growing number, spoke in terms that echoed the judge's concerns. These were lawmakers who had watched the erosion of institutional norms with private unease, who had shared their concerns in closed-door settings, who had hoped that the administration would self-correct without their having to break publicly with their party's leadership. The judge's eruption in open court made their private unease harder to maintain as a private matter. When a Republican-appointed federal judge says, in front of the country, that the executive branch is behaving in ways that threaten the constitutional order, staying silent becomes a form of complicity. The administration's response to the broader judicial crisis had followed a consistent and troubling pattern throughout the year. When courts ruled against executive actions, administration officials attacked the judges personally, questioned their legitimacy, suggested that unfavorable rulings were themselves unconstitutional exercises of judicial overreach. This strategy of delegitimizing adverse judicial decisions served a dual purpose. It mobilized the administration's political base, which had been primed to view the federal judiciary as an instrument of elite opposition to the popular will, and it created a rhetorical framework in which non-compliance with court orders could be presented not as executive lawlessness, but as principled resistance to judicial tyranny. Legal historians recognized the strategy immediately. It borrowed from playbooks that had been tested in other democratic contexts, in other countries, in other eras, contexts in which executive power had successfully eroded judicial independence by first delegitimizing the judiciary in the eyes of a sufficiently large portion of the public. The goal was not necessarily to eliminate the courts, but to render them politically irrelevant, to transform judicial decisions from binding mandates into merely advisory opinions that the executive could respect or ignore based on political calculation. It was a sophisticated attack on judicial authority, all the more dangerous for being dressed in the language of constitutional principle and popular sovereignty. The judge who erupted in open court understood this dynamic with the clarity of someone who had spent his career in the system being targeted. His remarks carried an implicit recognition that what was being challenged in the proceedings before him was not merely the outcome of a particular case, but the very concept of judicial authority itself. He was not just ruling on the facts and the law before him. He was, in the tradition of the great jurists who have defended judicial independence throughout American history, asserting that the courts would not be reduced to decorative institutions whose decisions carried weight only when convenient for the powerful. As the days following the confrontation unfolded, the legal and political fallout continued to accumulate. Other judges, emboldened perhaps by the public nature of this Republican-appointed jurist's stand, began issuing increasingly pointed orders and opinions. The rhetoric from the bench hardened. Language about executive accountability, about the supremacy of law over political preference, about the judiciary's obligation to maintain its institutional integrity became more prominent in judicial writings. The collective voice of the federal bench was becoming louder, more urgent, more willing to call out what was happening in direct and unambiguous terms. The administration pushed back harder. Political operatives talked openly about restructuring the courts, about limiting their jurisdiction, about mechanisms for removing judges who ruled against executive actions. These were not idle threats. They were part of a broader strategic vision for executive supremacy that had been articulated in various forms by administration allies throughout the political campaign and the early months of governance. The courts were identified as obstacles to the transformation the administration sought to achieve, and the approach to those obstacles had evolved from legal argument to confrontation, to something approaching open institutional warfare. For the millions of Americans watching these developments unfold, the complexity of the constitutional drama was matched by the urgency of its practical consequences. Federal workers who had been unlawfully terminated and were waiting for courts to compel their reinstatement found themselves caught in the gap between judicial order and executive compliance. Immigrants who had been detained in apparent violation of court orders found that judicial authority, however clearly asserted, did not automatically translate into physical release when the executive branch chose noncompliance. Communities that depended on federal programs stripped of funding by executive fiat found that court orders restoring those funds did not always result in actual restoration of service. The gap between judicial mandate and executive action was not a theoretical concern. It was lived experience for hundreds of thousands of Americans, and it pointed toward the deepest question raised by the confrontation in that courtroom. What happens when the executive branch decides, systematically and deliberately, that it will not comply with judicial orders? What are the enforcement mechanisms available to the courts? What happens when the constitutional architecture that was designed to prevent precisely this kind of executive overreach is stress-tested by an administration with the will and the organizational capacity to defy it? These are not comfortable questions. They do not have comfortable answers. The founding generation was acutely aware of the danger of executive tyranny and designed the Constitution with the intention of preventing it. But that design rested on an assumption that all three branches would, in the final analysis, respect the constitutional framework within which they operated, that the norms and conventions and shared commitments to the rule of law that gave the system its coherence would be honored even when they were inconvenient. That assumption is being tested in ways, and to a degree, that the architects of the Constitution could not have fully anticipated. The Republican judge who erupted in open court was not delivering a political speech. He was not endorsing a party or a candidate or an ideology. He was doing something simpler and more profound. He was asserting, with the full authority of his office and the full force of his convictions, that the law means what it says, that courts mean what they order, and that no executive, however powerful, however popular, however convinced of the righteousness of his own agenda, is exempt from the obligations that the Constitution imposes. He was saying that he had taken an oath, that he took that oath seriously, and that he expected the executive branch to do the same. Whether that assertion will ultimately prove sufficient to contain the executive ambitions of the Trump administration remains to be seen. The institutional resources of the federal judiciary are substantial but not unlimited. The moral authority of the bench is real but not self-enforcing. The constitutional protections that American democracy has long relied upon are durable but not indestructible. What is clear is that the confrontation now underway between the judicial and executive branches has reached a new level of intensity, a new level of explicitness, and a new level of consequence. What is also clear is that this particular confrontation, this moment of a Republican judge standing in his own courtroom and refusing to pretend that what was happening before him was acceptable, will be remembered. It will be remembered by legal scholars who write the history of this period. It will be remembered by future judges who will look back to this moment as a precedent for what judicial courage looks like in extremis. It will be remembered by the government attorneys who stood in that courtroom and heard in unmistakable terms that the conduct they were there to defend had crossed a line that a serious jurist found intolerable. And it will be remembered by the American public, which watched with a mixture of relief and alarm as one of the guardians of their constitutional order found his voice. The question that remains Hanging in the air of that courtroom and in the air of the broader constitutional crisis is whether that voice will be heeded, whether the administration will recalibrate its approach to the judiciary, recognizing that continued defiance carries costs that eventually become unsustainable, whether Republican lawmakers who have watched in silence will find their own voices, whether the institutional resistance now gathering force in the federal courts will prove sufficient to preserve the constitutional framework that has defined American democracy for nearly 2.5 centuries. The answer to those questions will not come from any single courtroom, any single judge, any single eruption of judicial fury, however justified and however significant. It will come from the accumulated choices of thousands of individuals across the legal system, the political system, and the citizenry itself. It will come from lawyers who refuse to make misleading representations to courts. It will come from judges who refuse to let those representations pass without challenge. It will come from lawmakers who recognize that their oaths of office mean something beyond the political moment. And it will come from an American public that understands, with the clarity that this moment demands, that the rule of law is not a partisan concept, not a liberal or conservative value, not a Democratic or Republican inheritance. It is the foundation upon which everything else rests. And when a Republican judge in open court makes clear that he will fight to preserve it, that foundation still holds. But holding it requires effort, requires courage, and requires a willingness to confront power with truth. The judge in that courtroom did his part. The question now is whether others will do theirs.